In this brief immigration law update video, I want to consider Article 8 and families with children post-KO Nigeria. On the 24th of October 2018, the Supreme Court gave judgment in KO Nigeria, which is UKSC 53 from 2018. And in that case, they found in the assessment of whether it's reasonable for a qualifying child to leave the UK, so that's under 276 ADE, and 117B6 of the 2002 Act. The question is focused on the child alone and doesn't weigh in the immigration history and the bad behaviour of the parent. Although they did find that the assessment is made in the real world context, and the real world context is that children are normally expected to follow their parents. So the question is it reasonable for the child to leave in the real world context that a child would normally follow their parents? Now that's been followed up by a number of cases. The Secretary of State tried to argue that, well, if the child's not going to actually leave and will stay with one of the parents here, we don't have to consider the reasonableness question. It doesn't arise. That was rejected in the case of JG 2019 UKUT 72 by the President of the Upper Tribunal. And the President found that the reasonableness assessment is a hypothetical question and it's to be considered regardless of whether the child is going to leave. That was also upheld by the Court of Appeal in a case called AB Jamaica, that's 2019 EWCA Civ 661. It's from the 12th of April 2019, and the Court of Appeal also found that the reasonableness assessment was a hypothetical assessment, although they slightly differed on their reasoning to JG. That case is also interesting because it considered what is a genuine subsisting parental relationship, and they disagreed with what was said by Upper Tribunal Judge Plimmer in the SR case, where she had found there needed to be an element of direct parental care, and said the words are to be given their plain meaning. No gloss is needed, and they approved what was said in the Upper Tribunal case of RK, which is 2016 UKUT 31. So it's a fact-sensitive inquiry of whether there's a genuine subsisting parental relationship. So that's led the Home Office to issue guidance on the 25th of July 2019. It's the excitedly titled Family Life brackets as a partner or parent, private life in exceptional circumstances. And in that case, in that guidance, they confirm that AB Jamaica says it's a hypothetical test regardless of whether the child is going to leave the UK. And also they say this: the starting point is that we would not normally expect a qualifying child to leave the UK. It is not normally in a child's best interest, it is normally in a child's best interest for the whole family to remain together, which means if the child is not expected to leave, then the parents or primary care of the child will also not be expected to leave. So that's really helpful guidance that you want to cite in your representations when making an application or in your skeleton arguments. They then go on to consider KO Nigeria and when it would be reasonable to leave, and it's worth addressing those factors because in KO Nigeria those factors were specifically approved. So have a look at the guidance, and when you do your representations, address them. So where are we at now with families with children and the reasonableness assessment? Well, reasonableness is focused on the child alone, but it's done in the real world context. It's a hypothetical question whether or not the child is actually going to leave. The question of whether there's a genuine subsisting parental relationship is a fact-sensitive inquiry, and the starting position from the Secretary of State's guidance is that they would not normally expect a qualifying child to leave and the whole family should be allowed to remain. I hope that's helpful. If you want some more detail, come along to one of my upcoming events. Thanks.